webinar. We're really excited to have all of you here. Today's webinar is on the Trump's executive order on transparency. How it will affect each segment of our industry. I can make an argument it won't affect us at all, but let's put that aside. Folks, we're really excited today. Fine. We're really excited today for one reason. We've broken every record with the number of attendees on this webinar today. So we have all of you to thank. Also, especially for the summertime. Usually, we'll get these kinds of numbers in September, October, November when it's a little cold outside. But you know what? Maybe if you're in Texas right now, it's 125 degrees. You'd rather be inside.
You'd be in air conditioning, and you got nothing better to do.
Folks, for the folks of you in the Midwest or in Texas right now, just on Saturday and Sunday here in Boston, it was like 97 degrees.
It felt like 100.
People freaked out. That's like a day in April for these folks. Anyways, as always, folks, with me is my Executive VP and General Counsel. Say hello to Ron E. Peck.
Hello to Ron E. Peck. Hello, Ron.
Next to him, we have our Director of, what are you called? Legal Compliance, Regulatory Affairs?
That's the thing, yeah.
Say hello to Brady Bizzaro. Say hello, Brady.
Hello, Brady. Sounds like a party.
Last but not least, the amazing, the wonderful, the only reason people dial in today, folks, it's our Senior VP, very senior. She's been here that long. She's been here that long, we call her a senior. You are a senior citizen here at FIA.
Essentially.
I was thinking more like a high school senior.
Folks, meet our Senior Vice President of Consulting, Jennifer McCormick. Say hello, Jennifer.
Hello.
Folks, as always, it's wonderful that you're here. Please follow us on LinkedIn. Matt, how many followers do we have on LinkedIn now?
3,650.
He made up that number, 3,658. Folks, a year ago, it wasn't even 2,000, so thank you so much for following us. In addition, it's no longer what was it called before?
The iTunes.
iTunes, they're changing it now to the Apple podcast, correct?
Yeah.
So, folks, listen to our podcast on Apple Podcasts. We've had some amazing ones. The one that got a lot of feedback was the one with Ron Peck, our own Ron. That went very well, but it's still not as good as the one we did with Pat Santos, our producer.
Honestly, that's when we jumped the shark.
The best podcast we've ever done. So thank you so much for listening in on that. If you have any questions or issues, feel free to contact us. You know that as well. So, folks, we're really excited about something. Already from our initial email blast, we have a couple hundred different people signed up to become PACE certified. It's going to educate anyone that's interested. You do not have to be a PACE client. We hope you become one, but you don't have to be a PACE client to sign up. Chapter 1 talks about the ins and outs of self-funding. Chapter 2 takes a deeper dive as it relates to federal preemption, adverse benefit appeals, determinations, and appeals. Basically, everything you want to know about self-funding, you can educate your internal people. Most importantly, educate your internal salespeople so they can then go out in the industry and promote your organization and why they should work with you over other people, as well as pursue and push our PACE service. Last but not least, Chapter 3 talks about what PACE is, what it does, how it's obtained, implemented, utilized, and then you become certified. It will be released on August 1st. We're really excited about it. Ron and I and our team, which encompasses a bunch of people, have had a lot to do with it. If you're interested, the contact information is not here, but you can contact Michael Vaz, M-Vaz, V-A-Z, at FIAgroup.com. He is coordinating the entire PACE certification program, and he will be glad for you to sign up. Next, here's our shout-out. Natalie, I can't even say this last name. How do you say it? Rothley? Does anybody know who this person is? I'm kidding. Natalie, you're one of our avid fans of all of our webinars, all of our podcasts. We appreciate you listening so much. Please know that Matt will be sending you a really, really big goodie bag. I'm assuming there's a T-shirt in there. There's I don't know what else. But I'm assuming she's in Texas. Maybe we don't need to send her a sweatshirt or a fleece or anything like that.
Okay.
But we definitely want to send her that backpack for sure. So thank you so much for listening. And again, if you're interested in getting a shout out, all you got to do is just keep emailing Matt over and over again, send him some money, and you will be shouted out as well. Now, just like last time, we'll be going over 3 questions that we're asking you to click on, correct? And answer.
So interactive.
The first question. What healthcare industry topic is getting a ton of airtime, but is likely overblown? I know this one. First, government plans, Medicare for all. Second, pharmacy pricing, PBMs, etc. Next, specialty drugs, air ambulance, dialysis claims. Next, I think this one's really bad. The public threats and our duties like opioids, addiction. And you guys saw the story some of these stories where like literally family members of some of the companies that own these organizations, the manufacturers, are being like threatened with their lives.
Yep.
And they can't go to the movie theater. And it's wild. Last but not least, new obligations, mental health parity, FMLA, etc. So it's pretty clear. A vast majority of people think the government plan Medicaid for all is getting way too much.
Feeling a little too much burn.
Well, you know what? It's going to be like that for the next year.
Enjoy it.
Right now, Brady's being told basically stop talking about it, Brady. That's what they're basically telling us.
Let's delete that slide.
The next question: what healthcare industry topic is being mentioned in passing? It's the opposite, but deserves more attention. Medicare for all.
Yeah, I'll say Medicare for all again.
Pharmacy prices, PBMs. The specialty drugs, dialysis, the opioid issue, and the public threats to our ever-growing crisis that we have when it comes to all these drugs. And last but not least, FMLA, mental health parity, etc. Which one of these should be talked about more to get more attention?
Yeah, healthy split here. It's overwhelming, yeah.
I think it's pretty interesting. You're seeing a lot here on the pharmacy, and it's high. So again, 80% of the people think pharmacy, some type of pharmaceutical, whether it's specialty or normal, regular, needs to be talked about more.
Got it.
Great. Last but not least, what healthcare industry topic is flying under the radar, but should be a focus?
Right.
Same 5 answers. Medicare for all needs to be focused on drugs, specialty drugs, opioid addiction, and last but not least, mental health parity, FMLA, etc.
Yep.
Industry focus, not media focus. Industry focus. In my opinion, it seems to me like the opioids should be the #1 focus that we're not talking about at all. That should be focused on. Getting people to find a way to not prescribe them a drug and give us some other means of doing so. But no one agrees with me. Good to know. Perfect. Mental health drives opioid. I very much agreed, Spencer. Thank you for that insight.
That's right.
So, next, folks, what are we going to be talking about today? Thank you so much for those of you who responded. Our problem purpose process, like we always do. Then we're going to turn it over to Jen McCormick and watch those numbers fly high when she talks about PGC's FAQs. Then the numbers will dip a little bit when we go over to Brady and his political update. And then lastly, when Ron talks, people just start hanging up again. Trump's executive order on transparency. We're going to be begging Jen to keep on talking because otherwise no one will stay dialed in. So, folks, what is the problem? Healthcare costs too much. What are we trying to do here at FIA? Make it more affordable for who? All of you. Folks, our clients are not you. Our clients are not TPAs. They're not MGUs. They're not stop-loss carriers. Our clients are not employers. Our clients are the actual employees and not their dependents. I hate that word. They're families. It's the family. Why? Because every hardworking American deserves access to high-quality, affordable health care, and we are excited to be able to do that on your behalf. So, folks, turning it over now to the lovely Jen McCormick. Jen, it's your last day here before you leave for vacation, right?
Yeah, it is.
So, folks, Jen's brother is getting married, her younger brother, and she does not like the fiance. Aaron, very interesting to know that.
Oh, no.
No, what I heard.
Lauren, I know you're listening. That is not the case. I'm very excited to welcome you to our family.
Anyway, take it away, Jen.
All right, #1. Can the plan compliantly exclude coverage for congenital birth defects in light of the prohibition on pre-existing conditions exclusions? So maybe some of you guys remember that about 10 years ago, it was totally acceptable and reasonable, and what we saw every day in our self-funded plans, to have pre-existing condition exclusions. That was normal until ACA came and gradually phased out the ability to have these pre-existing condition exclusions, first for those who are under 19 and eventually for everyone. And now there are concerns about what exactly does that mean for particular conditions or the requirement to offer coverage. And this doesn't have to be something as narrow as necessarily congenital birth defects, but this could be something a little bit broader. The underlying issue here is when we're talking about the pre-existing condition exclusions, it is based on the fact that something was present, that somebody had a particular condition prior to the coverage actually going into effect. So that is what the basis and the prohibition against this pre-existing condition actually is. It is in no way trying or requiring a plan to cover something under this caveat that wouldn't be otherwise covered in the first place, like a cosmetic surgery, for example. Another example here is that a covered treatment of an ankle sprain couldn't be excluded based solely on the date of the injury. So while this could be a little bit confusing, you should take a look at actually the facts and circumstances in your reviewing these, but just remember the actual intent and the background behind why the pre-existing condition limitation went into place in the first place, and that was to exclude things based on them being not eligible based on the date of service. Let's go down to the next question, which is whether or not a plan can compliantly charge tobacco users a higher premium. So wellness programs under ADA rules, HIPAA rules, all GINA rules, this has been a topic that a lot of people have been talking about, and right now we're still waiting some sort of guidance to tell us exactly what to do. But in general, if there is a wellness program, this would be something that would be appropriate if it was part of the wellness program. And just as a quick reminder, there are those two types of the wellness programs, the participatory and also the health contingent. And under that, there are certain ones that are based on you completing certain activities, so that you went for a walk, versus outcome-based, which are more related to whether or not you actually achieved a certain BMI, for example. So the wellness rules, keep an eye out on them, but if there is a wellness plan in place, just note that there are certain things that having a wellness plan would allow you to do that you wouldn't be able to do if you didn't have a wellness plan in place. And last but not least, let's talk about the concerns when incorporating some vendor programs. So it is not uncommon for us to be approached about whether or not or how a certain program can be implemented into a plan document. There are a lot of different considerations, not just the plan language. And in fact, when it comes to the plan language and putting together a program, the plan language is often the easiest piece. If you can articulate what actual benefits are going to be derived from the program, what obligations are going to be for the actual employees and their families, and what maybe incentives they might have as part of adopting or utilizing this program. But there are other considerations outside of plan language. I know it's probably unbelievable for me to say that, but other things that need to be considered when you're implementing one of these programs. So, for example, what exactly is being promised? Is there something that needs to be done that's going to require maybe a change with the administration? If that's the case, is the administrator aware of that? Is that going to create a problem with their existing ability to administer the program or administer the existing benefits? Also, by adopting this particular program, is it going to create any sort of conflicts or gaps with any other existing programs or benefits, like maybe a network agreement? Also, would a result of adding this program to your plan require you to have a conversation or maybe discuss stop loss? Maybe there's a change or an amendment that needs to be made, and maybe stop loss needs to sign off on that before it actually goes into effect. And outside of those issues, when you're making these types of changes, remember that there are timing issues when it comes to issuing the amendment and giving the notice to the plan participants. And maybe this type of change to add this program would require you to update the SBC. So it's short-sighted just to say that you can just put new language into a document and assume the program is going to be administered appropriately. Let's turn over to Brady for the political update.
Thanks, Jen.
The numbers just dropped. Just dropped. 3 people literally just left. We just watched it happen. Do you guys not see it?
I dispute that. I think I got to keep those polling numbers we can probably sell that to some of the campaigns on some of the issues they want to talk about. But for our issues here, there's a lot to get to in this political update. This month was the month in which the U.S. Court for the Fifth Circuit heard oral arguments in the Obamacare case. So this is the case that has been really going through the courts for, it feels like a year now, but really it was since last December. The case in which the federal judge in Texas basically ruled the entire ACA unconstitutional. It caused a bombshell and sort of had ripple effects throughout the legal community. And there are some takeaways, though, based on what I heard in the 2-hour oral argument, which I've heard at least 2 or 3 times, by the way, because it's really important to hear these oral arguments because you can get a sense of what the judges are thinking, what they may take into consideration when making their ruling. And this is a huge case, right? Like literally, if these judges decide to uphold the lower court decision, the ACA as we know it might go away. And so there's already some talk on Capitol Hill that they need a contingency plan to come up with some kind of a replacement bill, or at least parts of a replacement bill to keep the popular parts of the ACA in place. So what do we hear from this oral argument back on July 9th? First thing to note here is it's a 3-judge panel, 2 Republican appointees, 1 Democratic appointee. And some things came out in the oral arguments that I think are worth discussing. Remember, this case is primarily about a legal term called severability, meaning the individual mandate, as we know, has been zeroed out. Effective at the end of 2017 in the Tax Cuts and Jobs Act, we got rid of that mandate. There's no tax now for not having health insurance. And remember, that was the pillar upon which the ACA was upheld back in the 2012 case. So the question is, can the fact that the individual mandate has been zeroed out, can it be separated? Can it be severed from the rest of the ACA, which of course is like a 900 or more plus page case, or a law rather. So some of the questions that the justices asked of the plaintiffs and the defense in this case were basically, look, the ACA has a bunch of provisions that have nothing to do with the mandate, right? They have even some parts that talk about what calorie contents have to be posted or certain foods. And so they wanted to make sure they understood that the argument from the government here is that the entire law should be struck down. And it seemed actually to some people observing this that they were open to that argument. And that's important to note because the initial reaction from this case at the lower court level was that it's crazy. The idea that the whole ACA should be thrown out, not what Congress intended. Really, both sides of the aisle, you had legal scholars saying this is kind of insanity on print, was even some of the words that I read. But it was surprising to hear that the Republican appointees seemed interested in and open to the line of reasoning from the lower court. And frankly, they acknowledged what they called the 800-pound gorilla not in the room. Remember, this case was not defended initially by the government, so you had to have Democratic attorneys general step in to defend the ACA. And what you don't see, by the way, and you also had the U.S. House of Representatives intervene, which is a democratically controlled institution at this point. The court asked why the Republican-controlled Senate didn't intervene on the other side. If, in fact, in other words, if the argument is that Congress never intended for the whole ACA to be thrown out, that they did intend for the mandate to be severed, then why wouldn't the Republican-led Senate intervene to protect and say, no, here's what we meant. We meant the ACA to stay in place, where you do see that on the Democratic side. I thought that was a good question to ask. It's a good issue to debate, and there wasn't really a good answer, frankly, from the Democratic side about why the Senate did not intervene. And again, that's concerning because the implication is that this 3-judge panel at the Fifth Circuit might, in fact, be open to finding that the ACA is, in fact, unconstitutional without the mandate.
So, Brady, what's going to happen?
I knew that.
At the end of the day, what's going to happen?
So I should have added to this bullet here, what's at stake, Brady's reputation is one of those things, maybe my job. But I would say that I think the Fifth Circuit might go along with the lower court, and I think they're going to know that the Supreme Court will take this up.
You think
I think they will. I think they will.
Thank you.
And we'll get, in a couple of weeks, maybe by the end of the summer, we'll expect some kind of ruling from them. I think if I had to guess, and it's guesswork only, 2 out of 3 judges would overrule the Democratic appointed one, probably go along with the lower court, and they would probably find that
when that happens, I'm assuming when that happens, we will have a podcast or an email at least go out.
Oh yeah.
In regards to
if that's what's going to happen.
And then Brady's going to the Supreme Court.
Right. Well, you said
I said I would.
So what's possible, by the way, quickly, is if they do agree with the lower court here, they may stay their ruling or not issue a nationwide injunction, which is effectively what would happen. And the ACA might have some breathing space until the Supreme Court would be forced to take this up in 2020. We'll have to wait and see how that unfolds. A couple other quick updates here that are important for our industry. 2 setbacks here for the Trump administration with respect to drug pricing, an issue that a lot of you said should be talked about more in our previous poll. Well, unfortunately, they won't be talked about anytime soon in TV ads because despite the fact that the administration had pushed for and actually had gotten a final rule published, which would have required the disclosure of list prices in TV ads, unfortunately, a federal judge has blocked that rule, literally just 8 hours before it was supposed to go into effect on July 9th.
So give us an example of what the ad would have said.
It would have said...
It would have a listed price, or would it be at the bottom of the screen of scrolling, like you could barely read it? Or would it be visible?
So there weren't that many details in the reg about whether you had to have a scrolling word or slow down or whatever, but you could look at Johnson & Johnson, which already was publishing some of their prices in the ads. It's the list price, literally. The list price of the ad does not reflect any discounts, does not reflect what the consumer actually pays. It just says, here's what we charge.
How big was it? Was it noticeable on the screen?
Yes, noticeable on the screen for Johnson & Johnson.
And now it's
there was a lot of pushback from the industry about how, this will cause people not to seek needed care. They're going to think that's the price that they have to pay. And there was a bunch of lawsuits, of course, over this. It turns out, by the way, though, that this ruling by this federal court really uncovers a pattern that I've noticed, and I'm sure others in the legal community as well, where the administration has been frustrated with Congress's lack of movement on various healthcare issues, and they've taken it upon themselves to issue either executive orders or agency action to pass rules which have serious implications that typically you would have to do through legislation. And so I noted here, I'm not going to go through this dreaded law school case called Chevron, but everyone who took law school would know the Chevron deference standard, basically saying that courts usually defer to agencies because they're experts in their area. So
you would think that the agency would know more than they do relating to this particular issue.
And it's something that, it drives legal scholars mad because it's hard to say, when do you give deference? How much deference? It's a whole two-step analysis I won't get into.
That's a Friday night discussion, huh?
Oh, it's great. I'm so revved up for it. But a long story short is over the last couple of years, especially, the Supreme Court has really been pushing back on the Chevron deference principle. So basically, the courts are not giving the deference to the agency. So the Trump administration is being blocked in many cases on association health plans, on contraceptive mandates, now here on the drug pricing thing. So it's frustrating.
What happened with the Medicare Part D rebate proposal?
This one was a self-inflicted wound, and I think it's important to note because it would have perhaps formed the blueprint for how they would have tackled rebates in the private sector, which would affect our industry. But basically what happened is they were considering removing rebates for Medicare Part D. And that would have been billions of dollars that were removed because, in their view, rebates are driving up the cost of drugs. We talked about this previously in other podcasts, but I'll save you that analysis to say that, according to the government's own projections, though, they were worried that premiums would go up for the Medicare Part D beneficiaries, and so they got afraid and they withdrew it. And that was a big setback for HHS. They have been promoting it. There's some internal division in the White House, but just know that rule has been removed. So for now, rebates are safe going forward. But we'll have to look and see how Congress reacts on that issue. What Congress did act on, by the way, quickly, is the Cadillac tax. You talk about this off and on for years, I feel like.
Was it being pushed back?
Oh, 5 at least.
Before I got here.
It was a long road they kicked that can.
But look, that's what Congress typically does. They kick the can down the road, and they kicked it so far down that it was going to take effect in 2022. It would have imposed a 40% tax on high-dollar employer-sponsored plans. That's our industry, right? But the way that was worded, it would have affected actually 73% of employers. That's a lot of employers. 94% by 2026 because, look, they were seeing it as a revenue-driving opportunity. Thankfully, in the House, it's now been killed. That does not mean, however, that it's a law. It's got to go through the Senate, and there is a version with some co-sponsors in the Senate, but there's no date yet. I'm sure we'll look to us and decide to see where that gets.
You would think they want to get this resolved before the election because couldn't this be used by Democrats to say, hey, this is why we need to get rid of employer. I mean, you employers get paid this ridiculous tax.
Yeah.
Right? Absolutely. I mean, I would think that they would try to get employers and people to actually look at this and say, hey, maybe we need to go to a Medicare for All plan because this is going to kill us.
It doesn't help.
Right.
Yep.
Interesting.
Absolutely. So the last thing here I have on the slide is the short-term health plan. Just another note on another federal court ruling here. In this case, though, they did allow the expanded sale of short-term health plans. So again, this is a fear that it would impact the individual market, not necessarily our industry per se, but it's important because these plans are not ACA compliant. They don't have to comply with many of the ACA rules,
so
including
give us an example.
Health benefits.
I can purchase a plan in where was this?
Any state.
I can purchase a plan that is for a week.
Yep, as long as 364 days now. So if you want some kind of catastrophic insurance that doesn't offer you any kind of comprehensive care,
but they would probably have pre-existing condition requirements because if I knew I had a disease and I need to get a surgery, I buy insurance for 2 weeks.
That's right. Exactly, and that's why they don't have to comply with those ACA rules. Democrats are calling these junk plans, but they're very, very cheap. And now the expanded use could impact the individual market. We'll have to wait and see how that goes. A quick note.
At the end of the day, right, real quick, if you're healthy, let's say you're a healthy single person, and you can buy insurance for 364 days and renew it for 3 years, right? Again, you're not going to get renewed if you get a disease, I'm assuming. But if you're healthy and you want to buy insurance just to make sure you don't get like a broken arm or whatever, this might be a really good option, right?
And that's certainly the argument. That's the argument. And then the attitude is when you do have a disease, you can't be rejected from one of the other policies.
Right.
So it's sort of an adverse selection problem. So I thought this slide was important because it ties really well into the executive order we're talking about today, which is about transparency and pricing, what can happen when you don't have transparency. So I just wanted to mention that this spotlight bill that was covered by both NPR and Kaiser Health News of someone who had undergone dialysis treatment in the state of Montana. A 50-year-old personal trainer suddenly found himself with ESRD and needed dialysis. He did the right thing, called his insurance company, tried to find an in-network provider, and was told that there is no in-network provider or clinic in the state of Montana. They have that in writing. There's a record of it. That's important because they ended up going out of network for this guy's service. And, of course, there's a 90-day coordination period, as we know, with Medicare, and he had 14 weeks of outpatient dialysis. and they charged him $13,867 per session.
Medicare rate is $235.
That's correct. Yes, that's the Medicare rate.
Everybody on this, everyone listening,
that.
everyone listening should literally take a picture of this or use this case. Again, this was on NPR, right?
Right.
Yep. So this isn't Republican conservative radio that we're talking about here. This is on NPR talking about this outrageous bill. My question is this, right? Why was it that there was no in-network ESRD facility? Because, as you know, DaVita and Fresenius basically own the market.
70% of the market, yeah.
So if you're an insurer, you're a carrier, you're a TPA, you're trying to make a deal with one of these two behemoths, you basically have to, you're at their behest, right? You can't get a great deal. So I'm giving props to this insurer, Allegiance here, for, you know, at the end of the day, we can't have one in-network because it's just ridiculously overcharged. We're not going to have it in-network. It makes sense in a lot of ways.
So there's an epilogue of the story. It turns out there was one in-network facility that they just weren't aware of.
One.
And they were told that there was not one, but there was
one.
Correct. And they subsequently got onto this in-network facility for the rest of the treatments that he needed until Medicare could take over.
And what was the pricing on that one?
Not quite sure. It wasn't as high as that, though. The problem with this bill is this first bill from Fresenius where it's just crazy expensive. And I wanted to put a source there because they found the typical rate Medicare plus 400. So just the amount they charged was wildly crazy. This couple tried to do the right thing by calling their insurance, trying to find the right carrier. They weren't told.
Guys, just deal with that for a second.
Where to go.
Just think about this, right? And I'm sorry for keep cutting you off, but I am your boss. So the typical rate, according to, and this I think is, we have to emphasize more, Medicare plus 400%. Is a typical rate, charging 4 times what Medicare would get, right? So that's $1,000, roughly, not even.
Right.
Yeah. And you're looking at a $13,800 bill. What is the rate on that?
Well, 59 times.
Yeah.
Unbelievable.
So, 13 times what the crazy.
Yes, Mr. Hobson, you are correct. You have a calculator handy. Very well done.
So in sum on this here, the takeaway is that patients are often given wrong information. They're not told the price up front, and, you know, negotiation works. Really quick, I just want to give
really quick. The whole point of this is
we're going to get into the meat and potatoes.
When does Ron get to talk? Do you notice that we're doing this again, folks? For the thousands of you listening, thousands that are watching this, Ron has yet to get a slide. Am I the only one that notices this?
I'm the dessert at the end of the meal, Adam.
We are 30 minutes in. You have yet to say a word.
It's about to change. So,
all right,
just to give a brief explainer about what we're talking about with executive order. I think it's important people to know, but executive orders aren't actually changing the law. They're directing agencies to then propose.
How many questions do we get the day after this went down, Jen, asking how this is going to change anything?
At least 50.
Okay, good. So go ahead, Brady.
And the reason this is being passed away provides a framework, right? A federal framework. I put a case here, Gobiel versus Liberty Mutual, which represents an attempt by Vermont and try and require price transparency and to gather lists of prices. And it was preempted by ERISA. So to avoid ERISA preemption, if you have an executive order which directs agencies to take action, then what you'll have is agencies passing rules that apply federally, that you can't have subject to ERISA preemption. So just be clear on what it does and does not do. And, of course, expect legal challenges. So to go into the meat and potatoes, if you will, of the executive order, I'll turn it over now to Ron.
Dessert.
Yeah, I am the dessert. You know, we've already gotten to our entree. All right, so let's talk a little bit about this executive order. Right off the bat, let's all accept that any messaging from the top regarding transparency is a good one. So before we dig into this, let's all remember that we're very, very happy that this is getting the attention that it's getting, okay? That disclaimer out of the way, it's not a perfect solution just yet, and we'll talk about why that's the case. First and foremost, when we look at the attitude regarding transparency, all benefit plans, all insurance, forms of insurance are generally being lumped together. Everything from a traditional fully insured carrier straight through to a self-funded plan with a TPA. And the issue is that when you go and you look at the current status quo, you see things, for instance, I think, Adam ruins everything, which is funny because I say that all the time, but that's a different Adam. There's, a video online that explains the current health insurance, American healthcare. And one of the things they talk about is the way these network discounts are negotiated. And they talk about how the hospital basically sets this arbitrary number in its charge master, and that the carrier, which also owns the network, negotiates a discount. And when they need to present to their client a better discount, all the hospital has to do is first raise its rate. So now the discount is increased, but ultimately the amount that's actually being paid doesn't change. And if anything, it goes up. So there's an attitude that by revealing transparent pricing and focusing on what price is being charged, people generally think that that's going to stick it to both the hospital, but also the insurance. And again, this is where they're lumping everybody together. But we know that self-funded employers and the TPAs with whom they work, sometimes they have little to no control over those prices. And so transparency will actually benefit them, not harm them the way it's believed it'll harm the insurance carrier. So again, don't lump everybody together in the same bucket. Two, that patients care enough to shop around, that somehow sharing price information with them is going to change behavior for the good. And I'll talk a little bit more in depth regarding how not only is that not necessarily true, but may have the actual opposite effect. That patients are the ones affected by the lack of transparency rather than insurers. I've already explained that that's not necessarily the case. And that patients fully understand and embrace the terms and limitations within their insurance plans. I think it goes without saying that people don't read these days. All right, so opaque pricing structures benefit powerful special interest groups, large hospital systems, and insurance companies. Again, that attitude where we're lumping both the provider and the payer into one and assuming all payers are the same, which we know is not the case, and that we're leaving patients and taxpayers worse off. First of all, I think it's interesting the differentiation between patients and taxpayers. When we're talking about taxpayers, really we would be focusing mostly on government benefit plans, so Medicare, Medicaid. If we're looking at this from the perspective of private benefit plans, not exactly sure where the taxpayer comes into it, but we'll leave that as an aside. I think more importantly is the issue of how a lack of transparency hurts or benefits a self-funded health plan. One of the overarching issues that I have when it comes to transparency is now you know the price, so what? What are you going to do with it? Information in and of itself is worthless unless you actually do something with it. And I remember even as a kid when I used to watch G.I. Joe, and you remember at the end of every episode, you know, they teach you a lesson. This is what you do if somebody's got a bloody nose. This is what you do if somebody falls through the ice. This is what you do if your house is on fire, right? And what would they always say after the lesson? Knowing is half the battle, right? And so I used to, even when I was 6 years old, I used to question, what's the other half of the battle? How do I finish 100% of the battle? And I discovered on my own that the other half is actually doing something with the information. So not just knowing, but acting. So the question then becomes, with this transparency and this information, what are you going to do with it? And that brings up the whole question of incentives and disincentives and actually steering patients and getting them to care about the information that is now becoming available to them. So before we, again, what's the purpose? Is it to actually accomplish something, or is it just to know and do nothing with it? Unexpected bills at highly inflated prices from out-of-network providers that they had no opportunity to select in advance. Now it sounds like we're talking a little bit less about consumerism in general and focusing a little bit more on surprise balance billing, which we all know is a bipartisan hot topic that everybody can agree is evil, and now we're just trying to figure out the right solution. And you know that this has been a topic of conversation not only at the federal level, but also at the state level. And when we talk about surprise balance billing, we're mostly talking about either emergency situations where you didn't have an opportunity to choose, and I'm sorry to say it, transparency is not going to help in that situation. Maybe it'll help the plan or the carrier negotiate a better rate with a provider ahead of time so that if an emergency happens, you know that there's a better rate in place. But we're talking about emergencies treating at an out-of-network provider. So given that they're out-of-network, the price information is irrelevant. I didn't have an opportunity to shop around and take advantage of the transparency because I'm bleeding to death, all right? So it's not going to help in an emergency. Or you're going to an in-network facility where an out-of-network provider is practicing. Well, if you've determined that this facility is in-network, chances are you're not digging any deeper to determine, hey, is there a particular specialist I may or may not have to see that's out-of-network? And if so, what's the cost? And if I've already done my research and determined that this provider is, as far as I can tell, in network, the conversation ends there. I don't care about what they charge because they're in network. I'm just going to pay my copays and deductibles and let my plan deal with it. So again, this idea that transparency is somehow a solution for surprise balance billing, I'm not exactly sure that's the case. I think the solutions for surprise balance billing are going to have more to do with forcing providers to accept an objectively reasonable amount. Now, if you tell me that transparency is in turn going to help us eventually get to that objectively fair price that providers have to accept in these specific situations, maybe we're getting somewhere. But on its face, I don't necessarily think it's a solution in and of itself for surprise balance billing. Jen?
All right, thanks, Ron. So as you mentioned, shopping around for services. So another piece that's important to discuss here when we're talking about the purpose of this, and maybe this is one of the things that we can be excited about conceptually, what this is trying to do. Shoppable services make up a significant share of the healthcare market, which means that increasing transparency among these services will have a broad effect on increasing competition in the healthcare system as a whole. Competition, good or bad, that is not necessarily an unfair statement. We do want to make sure that there are the opportunities for consumers, for patients, for members, for their families to be able to make decisions based on having a sufficient amount of information. And what are shoppable services? So we're talking about shoppable services. These are the ones that are most commonly utilized and consumed by individuals that you can actually more readily research and compare and have that information in advance. So this is talking about having Ron mentioned the effective price transparency and what it is that we're trying to do and what it is that this might actually have an impact upon for consumers and providers and for hospitals, trying to figure out that there is actually a difference between what is billed and what is negotiated and what is paid and what is received. There are so many of these different distinctions that at the very least, having the ability to shop based on this information is going to have an impact and an effect on the competition, for better or worse. So let's talk about what the actual prices might actually mean. Okay, so this is something that we've talked about in the past before, informing patients about the actual prices being those that are charged based on the rates negotiated between the different insurers and the providers, not necessarily what's at the listed price. So here it's where HSS shall propose a regulation that's going to require hospitals to publicly post the standard charge information, including charges and information based on negotiated rates and for the common shoppable services and items. So before everyone attacks me, there are a lot of different opinions about what providing and posting means. First, whether or not it's going to be administratively, feasibly, easy to update, to monitor, to track, whether or not this actually is going to have any impact and whether it's consumer friendly or not, and whether this actually is going to provide good or bad competition. A lot of providers out there have a real problem with informing patients about the actual price, arguing that this is not the type of competition that is needed. In fact, they're arguing that by having the actual prices that would be available for everyone would increase the cost because everyone would be driving the private market.
It's the only thing in our country where you would actually have the prices and have competition and the prices would go up. What other segment of our economy does that happen?
I think that
But their argument is that would happen.
and it's funny because I don't think they're openly saying it, but but as long as the thing that they're not openly saying is that as long as the system is built around the scenario where the person who's actually receiving the good is not the person who's paying for the good, at least in their mind,
Right.
then why wouldn't you drive it up? If everybody has their father and mother's credit card, run those rates up because they don't care what the price is.
Right. The argument is, oh, geez, as a provider, the things that patients should be worried about, a recommendation from your physician, the fact that I provide the specialist service that can't be received anywhere else, and the bigger issue, which I do agree with, is what does that mean for the patient? What is the patient's out-of-pocket cost going to be? And that is something that seems to be missing when we're talking about actual prices, and how to calculate that is going to be a very complex.
And to add to the point, again, incentives. Right now, you can go on Amazon and look up the prices for certain medical devices. You can, like, for example, a nebulizer.
Mm-hmm.
On our plan, through our plan, you're paying $300 for that nebulizer right now. unless people know and are incentivized to care, they don't go on Amazon and buy that same one for $29.95. That's what it costs right now.
Yep.
So through our network, it's $300. On Amazon, it's $29. So even if you list the price, which is Amazon, unless you have a reason for people to actually look and care about the price, incentive-wise, I think there's an issue there too.
Right. There's a missing. Go ahead, Ron.
Oh, I was just going to say, there's a carrot, there's a stick, right? I mean, when you talk about out-of-pockets and high deductibles, those are all a lot of sticks. Adam, what you're talking about, where we're incentivizing somebody to actually shop around, that's a carrot.
Right.
But ultimately, carrots and sticks aren't going to do you any good if people don't know that they exist and when one's going to apply versus the other. So information is the third thing that's missing.
Right. Exactly. But there's a missing link here, and there needs to be some way that can be addressed.
Now, we're talking a lot about price incentives. What do I care about? And I've said this before, is actually quality. So the thing is this, right? Regardless of what you think about this executive order, the fact that they reference a quality roadmap and establishing a strategy to adopt and publish common quality measurements, at least they're getting the conversation started. That at the end of the day, we're trying to get a message out to people that price doesn't necessarily equate to quality. And my concern is that when somebody, and Adam already referenced, Amazon, right? You go online, you're doing your shopping. Your knee-jerk reaction is going to be that when I'm comparing two items, the one that costs more must be better. And it's only when I start to look at user reviews and things like that that I realize, oh, wait, this costs more, but it's actually lower quality than the one that costs less. And maybe that's going to steer me away from the higher dollar item. That required not transparency of price, because had I just seen the prices, I would have bought the more expensive one. It requires transparency of quality, and that steers me away. And the thing that constantly concerns me is that if we only share price with people, not only may it not adjust their behavior, particularly to your point, Adam, if it's somebody else's money, why would I care? But it may actually get them to spend more, because I'm realizing, like a sucker,
infection rates, et cetera. You don't know any of that stuff.
Like a sucker, I've been going to the cheap hospital.
Right.
Now I know which one's the better hospital. I'm going to go to that one. But when I know the infection rates, I'm going to say, I'm going to steer clear of that one.
So my question is this, right, on this slide. So we wrote down, but there are no really good ways to consistently measure quality. Is that true? Aren't there vendors out there who might be listening who might say, you know what, I don't agree with that. I think there are ways to measure quality.
I think you end up with enough of a sample size, you start to see the patterns emerge. With this argument that's being brought up by the opposition, Adam, regarding consistent measurements of quality is, again, when you're looking at an online or you're in a store and you're comparing items, generally speaking, those items are coming off of an assembly line where every single one is being built with the same components, the same parts, the same way. So if your stereo or your TV or your car is high quality, if I buy the same one, chances are I'm going to get the same exact quality. Whereas with healthcare, the argument is every single patient is different. So even if I've been able to avoid hospital-acquired conditions, infections, malpractice for every single patient, your case comes in the door and it's a fresh start with every single person.
Right.
So that's the argument that's been brought up. I do believe, however, that there are a lot of quality metrics that are tied to processes, procedures, tools, education, things that will apply universally to every patient that comes in that facility. So let's quickly talk about the next slide, which is about taxpayer-funded healthcare. So again, there's a lot of discussion regarding taxpayer. So not only how it's going to benefit taxpayers, but how we're going to also use the information that is received from government-funded or taxpayer-funded healthcare programs, which your knee-jerk reaction is going to say, well, how is that going to benefit me as a private benefit plan? The one thing that I do think is interesting is if that they start to utilize and leverage what tax-funded plans are paying more and more often and with greater transparency, is that going to potentially help facilitate things like reference-based pricing plans and Medicare-based pricing plans, where this information regarding what Medicare is paying, how they pay, the rules they apply, becomes more readily available? Will private payers start to look at that and say, well, why not me? Why can't I do that too? So I don't necessarily think this is an A to Z straight line approach, but can this information, as it becomes more available, start to result in other practices
But what
and other
information
methodologies.
is not available from a data standpoint in the Medicare world
Well,
now?
that's an excellent question. That's an excellent question.
So when they say more increasing access, what is that?
I think it's going to be less about the access and more about simplifying the information. Because you have a lot of entities out there right now that it's not that they can get the information, it's that they can take the information and boil it down into something that you can actually use. I think that's where the value is right now from the entities that are out there that are doing this as a service.
Speaking of things that we can actually use, the EO does contain one section on qualified expenses related to high deductible health plans paired with an HSA. So the order gives 3 basic instructions to HHS to propose 3 rules that would expand the use of HSAs paired with an HCHP. So I'll just go through them quickly. The first one here is pretty general. It says the Secretary must issue guidance to expand the ability of patients to select HDHP HSAs that would cover pre-deductible, low-cost preventive care to help people with chronic conditions maintain their health. So basically going to allow people with more range of conditions would be inclined to select these plans because they could use pre-deductible funds to cover expenses related to their chronic conditions. That's a good thing. That will expand the use of HSAs. Something else that will do that is if they increase the amount you can carry over in a flexible spending arrangement. Currently, that amount is below $500. It would be increased to $500 in unused funds, which could be rolled over from one plan year to the next. The third change, though, I think is most important for our industry and something we've been talking about for a while off and on, which is it would permit HHS, or would require them rather, to pass a regulation that would allow individuals to use those funds in a more expansive way. So currently, as you'll recall, you can only use your HSA funds for certain tax-exempt qualifying expenses, and those are defined in the tax code. This would be a regulation which would expand the tax code to include DPC, exactly. So you can now cover, it's huge, yeah, that would be absolutely big. So DPC, and by the way, also health sharing ministries.
So for those who don't know, that here at FIA, well, we don't have a health sharing ministry.
No.
We don't have that yet.
Not yet.
But we do have free DPC services for all employees that's paid for by the FIA group. So every employee at FIA and their dependents can have their own direct primary care doctor, right? I mean, I literally called Dr. Tremblay yesterday. So this would allow employees, patients, to use their money, these funds, for primary care.
To cover the premiums or the fees associated with it.
And right, a monthly PEPM fee, per employee per month fee. And right now, that's not possible.
Correct, because the IRS takes the view that does not qualify under the tax code as qualified expense.
Right.
And again, there's concern by some industry analysts, and by industry I mean the broader healthcare community, that this will again undermine the individual market because the fear is people are using DPC sort of as a way to avoid being on the individual exchanges. So I think the expanded use of HSAs will be a good thing for consumers and for our industry, but the individual market might suffer as a result. We'll have to wait and see on that one.
This next one, I know, Ron, you're going to talk about it. This is my favorite slide. And the reason why, I mean, again, I'm not talking about Trump, Obama, none of that. Just reading that paragraph of what he said, literally, I think, like, if that was a 5th grader, I think they'd fail. Like, I mean, and is that even English? But anyway,
it's all about the lawyers.
But I think it's funny that you guys put down in here that the principles on surprise medical billing. So what you're saying is Trump's remarks were the principles of, just so to be sure?
You know,
it's very interesting.
So yeah, the first thing I do want to address is the fact that you're being balance billed, you eventually end up in court, which means you end up with an attorney, and the root issue is that you have attorneys bills, and that's the main problem is how much attorneys charge. I take that a little personally. I gotta say, Adam,
the fact that the biggest thing here is the fact that President Trump says the lawyers' bills are bigger than anything they could have imagined. How about the hospital?
I was about to say, Adam, I don't know how much you charge, but when I look
we're very cheap.
Yeah,
we've proven that.
I look at a $540,000 dialysis bill, and I feel like it doesn't matter what I charge, I'm never going to run up that bill. I don't even think that the Bezos attorneys for the divorce charge that much.
Reading President Trump's statement, you would think that the problem with surprise medical billing is that legal bill is too high.
That's how it sounds. Yes, is that the conflict? When I look,
that's not the whole point.
We just talked about a $540,000 balance bill. I can't get off of that.
Stay tuned, because pretty soon on August 1st, we'll have a big announcement related to what you could do to deal with those big Legal
expenses, yes, and my legal bill would be $541,000. But, again, and we mentioned this before, the surprise balance billing, I do believe that surprise balance billing is something everybody agrees is a major issue from every end of the spectrum. And so it's this bipartisan, what I call a bipartisan crack in the armor. So again, resolving surprise balance billing is not in and of itself going to result in an industry-wide reduction on the costs and the charges from these hospitals and providers. It's really going to be in a very specific zone. But what I think it is going to do is it's going to create some comfort and some dialogue regarding, hey, are there situations where we can put a cap on how much a provider charges, which to date we haven't really done. So if this is just the first step in the journey, so be it. If using surprise balance billing as the Trojan horse is what you need to do, so be it.
The problem I have here is, though, that even within our industry, so Ron, you serve on the Government Relations Committee of SIA.
Yes.
I serve as chairman. Within our own industry, we can't all agree in regards to how they should calculate what the amount of the medical bill should be, what a reasonable payment is.
Well, I think that generally speaking, it's easy to say to someone, hey, that's not fair. When your response is, okay, what would be fair?
Right, and you can't come up with a number.
You
know it's not that number.
That takes it to the next level. So
right.
I think that the fact that we're at least saying, hey, this is not fair is an important first step, and it gets the dialogue going. The attitude that the doctor is one step below God and you just do whatever they say, at least we're pushing back against that. Now that you say, okay, what's the alternative? That's going to take next level thinking.
So before you get into your takeaways, can I give mine? Would it be fair to say that, and Brady, I want your feedback, and Jen, you too, before Ron gives us the final one. Would it be fair to say, in my opinion, the takeaway on all this is more of a talking point. It's good PR, but at the end of the day, not much has changed tomorrow over the next 6 months based on this passing.
Yeah, I actually, and that ties into
this,
Brady? Right?
I'll Ron, what's your prediction?
I happily go first. Yeah, I think that jives well with what I said at the beginning of this presentation about how this is just an order, right? Directing people to do things. So I think we have to wait and see what the concrete sort of bare bones legislation eventually says.
Jen?
Yeah, I've seen this, and I've said this before, helpful, but it's not changing anything.
Right, so you're not changing your plan doc language based on this.
Right.
Okay, Ron, your takeaway.
I think it just opens to the door that challenging the prices is okay to do.
So you're the most optimistic of all of us.
I think at least it gets the dialogue going.
Which is good, but it's not going to solve surprise billing with those dreaded legal bills.
Those legal bills. And the other thing, and this is one of my other major concerns, is what are you hearing about? Transparency of price. How much are they charging? How much are they charging? But here's the thing. The price is not what's relevant. It's what's actually ultimately paid. And these big bad insurance carriers and networks, they don't care about the price either. What do they negotiate? They don't negotiate prices. That's what's so funny. You hear all the media saying, oh, what price are they negotiating? They don't negotiate the price. They negotiate the discount. And that lack of understanding that we're not talking about what's being charged, but ultimately what's being paid, I don't think people necessarily can wrap their head around that. And so transparency of the charge master amount in and of itself, same thing with the drug pricing on the commercials, same issue. It doesn't resolve the core issue, which is how much can I pay? But it's a start. Exactly.
But the bottom line, folks, the last bullet talks about a system of incentives. The incentives are key. The whole point, I just did this presentation last week at HCA in Dallas, where it was on consumerism. And I talked about you can't get patients to become consumers unless they have a reason to care about the actual price, like they do in every other aspect. Like the amount that Brady paid for that shirt, I'm sure it's, what, $10? I can't even imagine. Whatever it might be. The point is, you have consumerism drives prices lower, makes quality higher. That's the American way. So that's what we need to focus on, and that's what we here at the Feed Group are very good at doing, by the way. Folks, check your inbox. The thousands of you have received the email. Matt Payton sent it. He's our marketing and PR guru here at FIA. Check it out. It's the FIA Group's second quarter newsletter. Everything that's happened, all the promotions that Brady got this past quarter, every one of them. How many times did he get promoted this past quarter? 3 or 4? It's on there. Last but not least, we want to thank all of you for joining us. Our next webinar will be August 21. It'll be steamy hot and 75 here at FIA. Guys, it's like 68 degrees today.
It is.
If you're not from me, it's 68 degrees in Boston. Our next webinar, August 21st at 1 o'clock, we will look at the poll results to figure out what we should talk about. I think we have an idea. But on behalf of Jen McCormick, Brady Bizzarro, our esteemed Ron E. Peck, and myself, Adam Russo. Thank you so much for joining us here at the Fee Group with the webinar. See you in a month.
Goodbye, Ron.